Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to get to circle back now to the king of crazy states, the one that is always perpetually on the gold medal platform of tyrannical gun laws. And of course, I'm talking about California. Now, listen, I acknowledge that we normally here are talking about your Second Amendment rights, but today we're going to be talking about the right to privacy under either the First or Fourth Amendment. Here's the problem. You see, there's really great debate whether or not the First Amendment or the Fourth Amendment truly actually even involves a true right of privacy. But here's the good news. The state we're talking about today, California, well, they solved that debate way back in the early 70s. That's right. They actually went back and amended their state constitution way back in 1972 and absolutely, positively added an individual right to privacy in there. Had a chance to read it, was looking for any exceptions. I didn't see any, but apparently the state of California thinks there is one huge exception to their constitutional right to privacy. So today, let's spend a few minutes and let's talk about the state that believes gun owners don't deserve any privacy. Okay, hey, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by the Sonoran Desert Institute. That's right, get ready to start launching your career in the firearms industry today. Get ready to start arming yourself with education. And most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through our most powerful act, which of course is education. Listen, the Sonoran Desert Institute has a degree, certificate, or program for just about anything that you may be looking for. So for more information, check them out in the description box below, or easier yet, just go ahead and visit them at sdi.edu. Okay, America, the case we're talking about today is the case of Barba v. Bonta. Try to say that one 5 times fast. It is filed in the Superior Court for the County of San Diego there in Southern California, and it is a lawsuit that is brought to us by our good friends at the Firearms Policy Coalition, which means, yes, there will be a link down below for you to show them some love. This is a challenge to California Assembly Bill 173. This is actually a motion for summary judgment, asking the San Diego County Superior Court to throw this law into the dumpster of history where it belongs. Now, let me try to break this down for you so you can understand the fast one that's been pulled on California residents. And you got to understand that if any of you are living in deep blue states and you think you got it terrible, I'm saying this to all my friends here at Washington, you usually don't have to look too far to find somebody who's got it worse than you, and that is almost always going to be California. And of course, since we're talking about California, we will do our obligatory shout out to our first ever California subscriber. Of course, that is Philip P. Philip P, who's been spreading the gospel of Washington gun law now for 3.5 years. Okay, now here's the thing. Back about 25 years ago, the California Department of Justice started collecting data on everybody who purchased a firearm. And I'm talking about some very sensitive personal data. As a matter of fact, the data that the Department of Justice collected included fingerprints, driver license number, home address, date and place of birth, citizenship status, race, sex, height, weight, hair, and eye color. Basically, just about anything except for the Social Security number. Now, here's the thing. Even though that data was collected, it was knowingly collected from all residents when they made firearm purchases. And this is important, there was a written disclosure that that data would not be shared by the Department of Justice with anybody for any reason other than law enforcement agencies if necessary to investigate criminal conduct. And I want you to understand, this disclosure, this promise that we are not going to share your data with anybody was in writing on 2 separate occasions. So anybody who was being subjected to this data collection was told in writing on 2 separate occasions, hey, don't worry, unless you're involved in criminal activity, this data is not going to be shared. But guess what? Yeah, the California Department of Justice was sharing it all along. And you know who they were sharing it with, California? UC Davis. And I want everyone in California to understand that UC Davis is absolutely complicit in trying to not only disarm you, the lawful and responsible gun-owning California resident, but they are also equally trying to trample on your constitutional right to privacy, and that is a constitutional right with the state of California enshrined into their state constitution way back in 1972. Yeah, for those of you who may be a little younger than me, there was a time where California was not completely bat crazy like they are right now. In fact, they realized that government overreach could be a significant problem. So when they amended their state constitution, The citizens of California spoke. The voters' decision to enshrine the right to privacy in the Constitution was motivated by concerns about the precise type of disclosure plaintiffs are subject to here. The privacy initiative's proponents were attuned to the unique harm arising from the government's compilation of personal information. The proliferation of government snooping and data collecting is threatening to destroy our traditional freedoms. Government agencies seem to be competing to compile the most extensive sets of dossiers of American citizens. Okay, so way back in 1972, in a point of sanity, the state of California realized, hey, we don't want to give government the authority to collect too much data. And let us remember, this was done in 1972, where the modern forms of data collection did not exist. Now, because of that, this California court had carved out a very clear rule as to whether or not California legislation was infringing upon the state constitutional right to privacy. And as the plaintiffs point out here, the California Supreme Court set the current framework for litigating a constitutional privacy claim. And they did so in a case called Hill. I'm not going to bore you with the details here, but they basically laid out a three-part test that works as follows. Under Hill, a privacy claim involves three essential elements. One, the claimant must possess a legally protected privacy interest. Which personal identification information is exactly that? Two, the claimant's expectation of privacy must be objectively reasonable. And three, the invasion of privacy complained of must be serious in both its nature and scope. Okay, and then if that three-part test is made, then the court, and this is where things always get dangerous, gets to engage in a balancing test, because then the test states, if a plaintiff satisfies this threshold inquiry, a court applies a general balancing test. The intruder can prove that the invasion of privacy is justified because it substantively furthers one or more countervailing interests. The plaintiff can then rebut a defendant's assertion of countervailing interest by showing that there are feasible and effective alternatives to defendant's conduct which have a lesser impact on privacy interest. Okay, so if it meets the three-part test, then the state can try to justify it by doing a simple little interest balancing. But then the plaintiff can come back and say, okay, even if you need to collect this data, there are ways to clean it up that will not infringe on the rights of privacy as much as is currently infringing. All right, that is the test. But here's the deal. After the trial court basically enjoined this law and it got to the Court of Appeals, the Court of Appeals basically skipped over the three-part test, went straight to an interest balancing, and shockingly went, no, this actually serves a legitimate government purpose. And even though the plaintiffs in this case said, well, listen, there's a couple of different things you can do here. You can allow people to opt out, right? Or you could redact some of the data so that it truly was anonymous. I mean, do we really need some of this data to do whatever research UC Davis claims it's doing? But the appellate court was having nothing of it because UC Davis was claiming, oh, no, this is absolutely gonna just completely mess with the legitimacy and reliability and validity of the data that we're studying here. And so therefore we need all of this information. And the Court of Appeals bought off on it. So here's the big problem, America, and I want you to understand what starts in California can often spread throughout the country like a really, really bad cancer. But all of a sudden, if people are required to give all of this data just in order to exercise a constitutional right, and then that data can be shared with just about anybody that government so desires, including not only public universities, but potentially private universities, oftentimes that are being funded by gun control groups such as Bloomberg or Everytown, you literally end up in a situation where a person goes in to do a firearms transaction, pays for all the additional paperwork that needs to be done, and is essentially funding their own disarmament. And listen, unless California had some other kind of nefarious purpose, such as to create a state gun registry, or to just dox all gun owners, or to just have all the necessary data you may want for either prosecution or confiscation, well, there's no other reason other than to have this data in an anonymous format. So the only reason that the state of California argues that they need all of this data in the raw format that they're getting it, because they have far more sinister and far more nefarious plans for it. Okay, the case once again, say it slowly, Barba v. Bonta. We're going to link it all up down below so that you guys can geek out on it for yourself. Link down below also for the Firearms Policy Coalition if you want to show them some love. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, and in California, that is about this much right here. You should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If If you got an idea for a video we should be doing around here, cool. Click on that link right there. Tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.